Yes, good evening to the participants of the JCJ 2022 main examination, which is going to be held on 26th November 2022 if it is not postponed over there. Participant, read what I posted on the screen. Unmute and read what I posted on the
Civil
screen.
Procedure Code Res Judicata, the thing adjudicated, Doctrine of Restitution. WritingLaw.com, Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania, Post Office Box number 307, Malimbi, Mwanza, Tanzania, East Africa.
Thank you very much. So now, without wasting the time, let me go to the yesterday class. Then we made, here I put the asterisk. Let me go to the asterisk where I stopped last in my yesterday class, going back to the, yes, because it is the asterisk is there, we can just type it, then we can, yeah. So here up to that extent that I made my class yesterday, then let us see that how to defeat the res judicata. And I already told that what is the res judicata? The thing decided or the thing adjudicated.
Yes,
The doctrine of res judicata would not apply to the case until the conditions are met. What are the conditions? The essential condition for the applicability is that the succeeding suit or the proceeding is founded on the same cause of action. There should be a same cause of action on which the former suit was founded. That is the criteria. At that time, the res judicata will be applied. The principle of res judicata can be defeated when the parties has filed the suit on a reasonable ground. For example, in case of a public interest litigation, that is PIL, has been filed, there is no reason not to extend the doctrine of res judicata. And the PL has been filed with a bona fide intention and the litigation cannot end. So whether the PIL, the res judicata will be applied or not, because there are many PILs are there. The cause of action is different. There is the environmental pollution is there, the PL is filed. And who is the person who is very much famous lawyer and who filed the cases in environmental law? Participant, tell me what is the advocate name and who has filed the many PIL cases in environmental pollution. If you know it, you tell me. If you don't know it, you say pass on.
Pass on.
MC Mehta.
MC Mehta. Okay.
It is a very famous Mahesh Chandra Mehta, if I not be mistaken. So he filed a case.
Yes, sir.
So can the court will take the res judicata because the PAL is based on different factors. If the same cause of action would be there, then the res judicata will be applied. If the action will be that different, then res judicata will not be applied. Am I right?
Yes, sir.
So that is the thing. In the PAL, generally, the cause of action are different in nature, and hence res judicata will not be applied over there. So now let us see the criticism to the res judicata. What are the criticisms available are found in the res judicata? A res judicata can also be applied to judgment that may be contrary to the law. So how we can see? The doctrine of res judicata has been used for a long time and it encloses a general effect of one judgment upon another trial or proceeding. It includes the matter not only those of bar but also those matter which should be litigated. It is bar to that extent when the cause of action arises on the same, at that instant the res judicata will be applied because the same cause of action the court has given the judgment and that judgment holds good if such a nature of the cases are filed and based on the same cause of action. Is it clear? Say yes or no.
Yes, sir.
For example, if a case has been dismissed on a specific ground by the court of law or the equity and it is not deemed as a final judgment and technically res judicata will apply but it is not justified. Suppose if it is any judgment which is not final, then res judicata will not be applied because the people will go for the appeal also. In the appeal, sometimes the Supreme Court may hold the judgment of the High Court, or the Supreme Court may overrule the judgment of the High Court. So if the Chancellor has denied equitable relief on a principle, but it was held by the court that the plaintiff is barred from the proceedings as a legal remedy. If it is the same cause of action, then the proceeding will be barred because res judicata will be applied over there. Most of the equity cases involves res judicata and don't get beyond the collateral estoppel. In the equity principles are concerned, no one can enrich himself at the cost of the others. That is the equity principle. As it raises the difficulty of overlapping the more than the failure to litigate the issues. So when we failure to get the litigation, that means on the same cause of action, if the case is decided, then the res judicata will be applied. But the cause of action is the different, like the PIL, the cause of action may be the different from case to case. At that instance, res judicata will not be applied. So the title to real estate, the right to collect rent depend upon one and the same construction of a will. If in an interpleader over the rents, for instance, rent control act is there, rents are there. So every place rent will be the different from place to place, area to area, and depends upon the parties contract, how a rent or lease agreement could be made. So A got the decree, B appealed without superides, and second a reversal, but before his appeal was decided. In the first one, the case is dismissed. Suppose the second one, it is reversed the first decision of the court and had sued him in a ejectment, invoking the decree and recorded a judgment for the real estate. B did not appeal from this judgment, but after the reversal of the decree, he sued an ejectment for the land, relying upon the reversal. So if a person will not go for the appeal, at that instance, he loses, because in appeal, there will be some limitation period would be there. In the limitation period, he should have to go to the appeal. Suppose if a person did not go for the appeal, that means whatever the judgment which is given or delivered by the court will be holds good. On the same cause of action, again, a person could not file a case. And then the res judicata will be applied over there in such cases. Suppose if there is a chance for the appeal, if you have a person goes for the appeal, at that instance, if the judgment holds the same, then the res judicata will be applied. If the judgment comes in the different order, then the res judicata will not be applied over there, and it will not be taken into consideration as a precedent, because appeal chances are there. If the appeal period is over, at that instance, the final judgment. If the final judgment is given and delivered in the merits, at that time res judicata will be applied. In case the judgment has given in the erroneous, or because fraud is there, then the res judicata will not be applied. That's what we have seen in the earlier classes. So now let us see what is the restitution. The restitution, doctrine of restitution, which the section 144 of the CPC says about it. The doctrine of restitution implies to bring the aggrieved party to the original position, where the benefit of the erroneous judgment of the court is received by the other party who was not entitled to such a benefit. In general, for instance, either you say the lease of the land or the house. At that instance, if a person dragged it intentionally and erroneously, he put it for a longer time and enjoys the harvest of the land or the possession of the land, and he enjoyed it for a longer time till the case will be decided, whatever the profit he enriched, that should be returned back to the owner. That is called a mesne profits. The mesne profit should have been given to the owner. Otherwise, he is enjoying at the cost of the others, because the judgment which he received is erroneously made, and he prolonged it, and he harvested if it is a land, and if it is a house, he has collected the rent. That is the mesne profits. So restitution is now a new concept, and section 144 merely gives a statutory recognition to this principle. So if a person has lost it because of this prolonging of the judgment, and which took place at the time he enjoyed that period, whatever the enjoyment of the period he got the benefit, that benefit should be returned back to the owner of the property, because he erroneously hold the land Either it is agricultural land, he harvested. If it is a building and he has taken the rent, so whatever the rent he has collected, he should be returned back to the owner of the land, because he erroneously dragged the decision by bringing the action in the court. So section 144 of the CPC deals with the application of the restitution. Restitution means bringing back to the same position. That is so section 144 states that when a decree or order of the court has been, the first bullet, varied or reversed in any appeal, revision or other proceedings. Second bullet is set aside or modified any suit instituted for that purpose. At that instance, suppose if it is erroneously made it over there, and again the person who lost it, then whatever the profits he earned at the time or during the time of the position of the land, that profit should be returned back to the owner, because owner has lost such a profits, hence bring him back to the original position by paying the amount to him. That is the restitution of the doctrine of restitution. So the court has passed the decree or order will grant a restitution on receiving an application of the party entitled to the benefit. So a party who got entitled to the benefit, and he should have to return back the profit and the benefit to the original owner, because he kept the property with a bad motive, number one, and for dragging the case by filing in the court, and the court decision comes later. Meanwhile, he will enjoy the benefit. Whatever the benefit he enjoyed, he should be returned back to the owner of the property. So that is the doctrine of restitution would be there. Let us see the one of the case. The court in the case of the Mahji Bhai, Mohan Bhai Bharat versus Patel Mani Bhai Gokhale Bhai, that is the case law, and held that an application for the restitution is an application for execution of a decree. So restitution is nothing but execution of a decree. So a person filed a case of the restitution of the property is concerned, it is nothing but application of the decree of the execution of a decree it is. So whatever the profit he earned it, the person by holding such a property, he should have to return back to the decree holder. That means a person who filed the case for the restitution, he is like a decree holder. Here the restitution of the property or getting back the benefit which is arised in the property by holding it, by prolonging it. So the Supreme Court in the case of Lal Bhagwat Singh versus Rai Saab Lala Sri Krishna Kishan Das held that the party who received the benefit of the erroneous judgment is by law under the obligation to make a restitution to other party for his loss. The other party means the party who has given the property for the lease, the owner or landlord who has given the lease of the land for the irrigation, but he erroneously dragged judgment, and meanwhile he got the profit, and that profit should be returned back it, because the owner lost such a profit. Did you get the point of this one? And who got the benefit? The defendant. How? By erroneous judgment. But later on, the plaintiff filed for the restitution of, and the whatever the loss would be there, and which the other party got it, that should be returned back. The benefit should be returned back, means the loss should be compensated. So that is called restitution. Bring back him to the original position as if he did not lose anything. Is it clear? Participants. That's why equity principle says no one can enrich himself at the cost of others. Whatever the profit he received it, in the legal terminology we can say mesne profits, mesne benefits. I think MESNE, mesne benefits, BENEFITS. So let us see this. The same view was reiterated by the court in the case of Binayak Swain versus Ramesh Chandra panigrahi. The doctrine of restitution means that on the reversal of a decree or a order, an obligation is imposed by the law on the party who has received the benefit of the erroneous decree to make a restitution to other party for his loss. If a party who lost it because of the erroneous judgment or decree gained by the other party, meanwhile he enjoyed the benefits, the benefit should be returned back to the or other party who is the owner of the property because he incurred loss. Meanwhile, he enjoyed the property's benefits and who got the erroneous decree. So the obligation automatically arises when the decree or order is reversed or modified by the court. Suppose the order is modified over there, it is in the favor of the plaintiff, is in the favor of the defendant. At that instance, he cannot get the profit. If it is erroneously that he got the decree, at the time, whatever the benefit he got it, he should return back to the law. He returned back to the other party and who got the loss. So that is the idea behind it. So it is necessarily carries with it is the right of restitution for all the things that have been done under the erroneous decree. So on the erroneous decree, whatever the party he got the benefit, that benefit should be returned back to the other party. The court, while making the restitution, is under a duty to restore the parties as far as possible at the time when the erroneous action of the court displaced them. So when the court displaced the erroneous action, at that instance, the other party who got the benefit should have to return the benefit to that party who got the loss because he is actually the owner of the property. The apex code in the case of Union Carbide Corporation versus Union of India, what is this case law? Can you tell me? Union Carbide Corporation versus Union of India. What is another name for this case law? Participants, if you know it, you tell me. If you don't know it, you say pass on. Speak. Participant, are you with me? Yeah, it is. It's not there. Yeah, it's logged out. So Union Carbide Corporation versus Union of India is nothing but Bhopal gas tragedy case law. That is MIC case law, methyl isocyanate case law. India held that restitution is a principle of equity and is a subject to the court's discretion. Section 144 of the CPC does not grant any new substantial right to the party not already obtained under the general law. The court is obliged to ensure that no one goes back with a feeling that he was impaired by an act which he did not on the faith of the court's order. So here what I want to say is, if a person who enjoys it, the benefit on the erroneous decree, he should have to return back the benefit to the other party who lost it because of the erroneous decree. So that is the central idea of that one. Now let us see that what is the maxim. Participant, are you present? So here another case law says, actus, not case law, Latin maxim, actus curiae niminem gravabit. So what it means, the Latin maxim actus curiae neminem gravabit means the act of a court should not affect anyone and is founded upon the principle of equity. So the act of should not affect anyone, cause loss to anyone, and is founded upon the principle of equity. The equity principle says no one can enrich himself at the cost of others. That is the equity principle. So at that time, the court is obliged to ensure that no one is endued by its order and it should not pass any order to the prejudice of any person. The apex court reiterated the maxim of actus curiae neminem graviabit in the case of Odisha Forest Development Corporation versus Messrs. Anupam Traders Limited, it is very much clearly mentioned, no one can enrich himself at the cost of others on the erroneous judgment. So the party who got the benefit should return back to the other party and who got the loss. So that is called the restitution. Now let us see the conditions. What are the conditions are there? In applying for the restitution, the following condition must be fulfilled. When you apply the restitution of then the following condition must be fulfilled. The decree virgule order must have been varied or reversed in any appeal, revision or is set aside or modified. The party in respect of the reversed or modified decree or order must be entitled to benefit by way of restitution or otherwise. The relief claimed by the party must be properly consequential of the variation, reversal, setting aside, or modification of the decree or order. So condition is, if the decree is modified over there, it is justified over there, at that instance, he need not to return the benefit to him. But if it is erroneously made and it is reversed over there in the favor of the plaintiff, then whatever the benefit the erroneous party got it other party should have to return to the another party. So that is the condition which will be there. Let us see the Orissa High Court in participant. Could you read this case law? Are you there? Banchani D. Das versus Bhanu Sahuani laid down certain principles to be followed for the application of restitution. What are the principles? Let us see that. There should be an erroneous judgment. What is the condition? There should be erroneous judgment passed by the court. With this erroneous judgment, the person whose favor it is passed, he enjoy the benefit of it. At that instance, the other party may file it. Let us see that what is said. The first condition, they say there should be an erroneous judgment passed by the court. The party to the record must have received the benefit of the erroneous judgment, means the judgment in the favor of the party, he got the benefit of the erroneous judgment. The party applying for the restitution, means the party who got the loss and who applied for the restitution must show that as a consequence of the erroneous judgment or decree, the party received the benefit, because the other party received the benefits based on the erroneous judgment. Excuse me. And the party should have to show it. At that instance, whatever the benefit received based on the erroneous judgment should be returned back to the party who filed for the restitution, and the loss, he should be compensated by the party who got the benefit based on the erroneous judgment. So the erroneous judgment or a decree must have reversed in appeal. It should be reversed over there, then only the benefit will be returned back to the party who filed for the restitution, and the loss which he got it would be compensated by the benefit from the other party who got the based on the erroneous judgment. That is the whole central idea of it. Who may apply? Who may apply for the restitution? The party who is the owner of the property and the party who got the loss because the other party on erroneous judgment enjoyed the benefit of it. So that let us see. A person may apply for the restitution who, now let us see, he is a party to the order or a decree being varied, reversed, set aside or modified. So whatever the first order which is given in the favor of the other party, that should be set aside, varied and reversed or modified, is entitled to any benefit by way of restitution or otherwise in respect of the order or decree being varied, reversed, set aside or modified. So if the first erroneous order would be there, either it should be by filing the case by the plaintiff for the restitution, the decree being varied or reversed or set aside or modified, and he will enjoy the benefit of it, and that person should have to apply it. Next, against whom the restitution may be granted. The same thing, the court may grant the restitution against the party who has wrongly received the benefit on the erroneous judgment. Under the erroneous decree or order of the court, the party receiving such a benefit is under the obligation, a duty to make a restitution to the party for that he has lost. The original party who lost the profit, who lost it because the other party erroneously benefited because of this decree or order. That is the idea. Participants, are you there? So now let us see that who may grant restitution. The court which has passed the original decree or order may grant the restitution to an application being made to it by the party who is entitled to benefit from such a reversed or varied decree or order. So the various reversed order, varied order, decreed order, and for that man, that person, the court will give the benefit. So that is the, who will give the party will file the restitution and the court will grant the restitution because an erroneous judgment the other party got the benefit of it, but the original party who executed the restitution or filed the restitution, and when the decision is varied and decreed, modified, and he will get the benefit of it by the court. Next, what remedies can the court can grant? What are the remedies court can grant? The court under section 144 can make any orders as a consequence of a decree or order being varied or reversed or modified or set aside for refund of cost and for the payment of interest, damages, compensation, and messenger profits. So there are all the court can grant it. What are the things? Payment of interest, number 1. Number 2, damages. Number 3, compensation. Number 4, messenger profit. Means whatever the profit he got it in the period of the erroneous judgment when the other party filed the restitution, and the decision may be, the first decision may be the reversed, modified, or set aside, then such a party would have to refund to the original party the payment of interest, damages, compensation, and the messenger profits. So now let us see the nature of proceeding. The nature of proceeding is concerned under section 144 is the execution proceedings. The restitution is nothing but execution proceedings. The purpose to get an order or decree into effect is called execution proceedings. So the purpose of get an order or a decree reversing the first or modifying the first or set aside the first, that is execution proceedings, which is in the favor of the plaintiff who filed it. The extent of restitution, how extent the restitution can be made. Section 144 is not exhaustive but inclusive. It is not exhaustive, it is inclusive only. Even if a matter does not fall within the scope of the section 144, the court has the power to grant the restitution on its discretion. In case the plaintiff doesn't file a case also, the court may grant it suo motu because the other party got the benefit on the erroneous judgment. Then the court will execute the petition of the plaintiff. Even though the plaintiff did not file the restitution, the court has the discretion to grant the restitution on to the party and who got the loss. So inherent power of the grant restitution. What are the inherent powers are there to grant the restitution? So under section 151, earlier we discussed only 144. Now when you speak about the inherent powers to grant the restitution, then we can tap the section 151 of the CPC. A court has an inherent power to make such order as may be necessary for meeting the ends of justice to or to prevent the abuse of the process of the court, other than the power to grant the restitution under section 144. Other than the grant of restitution under section 151, the court is having inherent power to grant the other remedies also. So section 144, The power of the court to grant the restitution is not confined only to 144. The court has an inherent power to grant the remedy of restitution where the section 144 does not apply. In case where the section 144 does not apply over there, the court may take the advantage of the section 151 and grant the other remedy also. So that is the thing which is there. The power of the court to grant the restitution is not confined only to the section 144. The court has the inherent power to grant the remedy of restitution where the section 144 does not apply, but 151 can be tapped over there in such a situation. So there are different circumstances in which the court can order to restore the status quo ante, previously existing state of affairs, bring back to the original position, to meet the ends of justice. To meet the end of justice, the court, even though they could not make it under section 144 of the CPC, but it can made under the section 151 of the CPC, the other remedy. It is other remedy when 144 fails. It was held in the K.N. Krishnappa versus T.R. Gopalakrishna Setti that under the section 151 of the CPC, the inherent power of the court can be invoked for restoring the parties to the position in which they were or prior to the execution. Prior to the execution, what is the position of him? Bring back to the original position. The inherent power would be there, and that is decided in the above case law. That is the K.N. Krishnappa versus T.R. Gopalakrishna Setti. The court used the 151 CPC and bring back to the original position of the parties and who is incurred the loss at the cost of the other party and who got the benefit on the erroneous judgment. So bar of a suit, when a bar of a suit would be there. Section 144, subsection 2, bars a separate suit instituted for obtaining any remedy if restitution or other relief could be obtained by making an application under section 144 class 1. When you got the benefit in the 144 subsection 1, at the time it clearly says one cannot apply for the same again, the cost or damages for it, because that proceeding will be barred because he already enjoyed all by the virtue of the section 144 subsection 1. So section 144 subsection 2 is bars the remedy when a person already got the remedy under the 144 subsection 1, which is the restitution, doctrine of restitution. Then another key factor or key element or key terminology is caveat. What is the spelling? Caveat, what is the spelling? C-A-V-E-A-T, caveat. Generally we will pronounce it as a caveat. Section 148 capital A of the CPC deals about the caveat. Is it clear? Participants, are you hearing me? I did not get the reply from you. Now let us see what is the meaning of caveat. The caveat in Latin means let a person be aware. Let a person have a knowledge of it. Be aware. Let a person have a knowledge of it. Let the person be aware. Let a person brings to that notice. And in law, it may be understood as a notice given asking not to act in a certain manner without informing a person who gave such a notice. So whenever a person wants to fire an action, a notice should be served to the other party. That is called caveat. Under the Civil Procedure Code, the provision of caveat is dealt with the section 148 capital A. Even though CPC does not define caveat in case the caveat is not defined over there, but its application will be made in cases. Let Nirmal Chand versus Girindra Narayan. The court defined caveat as a warning given by an individual to the court that no order or judgment shall be passed without giving the notice or without hearing the caveator. So wherever a decision would be given over there, bring to the notice of the other party. If they want to file the WS, if you want to defend themselves, let them defend it, but the notice should be given to them. If the notice will not be given, a new thing cannot be brought to the court without the notice of the other party. The person who files a caveat, oh, it is run. The person who files a caveat is called the caveator, and the person who has instituted a suit is likely to do is called the cavity. Yes, the person who files a caveat is called the caveator, and the person who has instituted a suit is likely to do so is called the cavity. The main object of a caveat is to ensure that the court does not pass an ex parte order and that the interests of the caviter are protected. So caveat also reduces the burden of the court and bringing an end to the litigation as it reduces the multiplicity of the proceeding. So a notice should be given over there, that is a must. And the caveat to the cavity or caveat to the caveat and vice versa, it should come to the knowledge of them. As the purpose of the caveat was to save the cost and convenience of the court. In Kattil, Vayalil, Parakkum, Koilat versus Manil, Padiyayil, Kadese Umma, that is the case law. The court held that no caveat can be lodged by a total stranger to the suit. So a stranger to the suit cannot lodge a caveat by a total stranger to the suit. At least the person should be connected with the suit and he should bring the caveat. The caveat or cavity should be there. When there is a little relation should be there, but a completely total stranger to the court cannot be lodged the caveat. So when to lodge a caveat? Then according to section 148 capital A of the CPC, when people apprehend, here apprehension means fear, that some case against them is filed or is about to be filed in any court of law in any manner, they have a right to lodge a caveat. So before you are filing a case in the court of law, you have to bring to the notice of the other party. If he could not respond to it, then you can file a case in the court of law. But all of a sudden, without the knowledge of the other party, you cannot file a suit directly. And moreover, the court also asked it, whether you have given the notice or not. And the proof should be there that you have given the notice. That is the reason that it should be if it is by post, acknowledgement due is the proof that he has made the caveat. The caveat may be lodged in the form of a petition under the following circumstances. How a caveat may be lodged and what is the form of the caveat in the following circumstances. During an ongoing suit or a litigation, in that the application is already been made to or is expected to be made, the suit is about to be instituted, and that a suit, an application is expected to be made, at that time, definitely the other party should have the knowledge of it that we are going to file a suit. Thus, firstly, it is always about an application in a suit of the proceeding, and secondly, the suit or proceeding can be in the present, which is already instituted, or it can be in the future where the suit is not instituted yet, but the same is expected. In all such a situation, the right to lodge a caveat arises. Either going to present the suit, or in the future, or in any case, all the circumstances, the caveat is, we are to the right to lodge a caveat arises. Means, bring to the knowledge of the other party is necessary and must and mandatory. Who may lodge a caveat? Section 148 capital A further provides that a caveat may be filed by any person, not total stranger, by any person, whether a party to the suit or not, as long as a person filing the caveat has the right to appear before the court. he should have a right to appear before the court in regard to the suit in question. In one way, in another way, a little connection should be there. A total stranger cannot file a caveat. Thus, a caveat can be filed by a third party as well, definitely third party, but the third party should be appear for the suit, appear for the trial. So, if they in any manner are connected to the suit in question, how a third party in any manner connected to the suit is a question. If it is by any other means it is connected, yes, he can lodge a caveat. However, it is already discussed that caveat cannot be lodged by a person who is a total stranger. The above case law we read it. A total stranger cannot lodge a caveat to the case, and the same principle was laid down in the Katil, Vayalil, Parakum, Koilet, and Manilal, Pakadiyali, Kadisa, Ummah, that we dealt it. A total stranger cannot bring the caveat. To conclude, this clause is a substantive in nature, and a caveat may be filed by any person claiming right to appear before the court. So, a total stranger cannot, but a third person who is appearing and claiming to appear can lodge a caveat. So, a total person cannot bring lodge a caveat is observed in the Katil, Vayalil, Parakum, Koilat versus Mandil, Padikyal, Kadisa, Ummah. That is the case law. Now let us see, let me make it out. Yes. Where can a caveat lodged? Question is, where can a caveat be lodged? The answer, let us see it. And the home, then I can make it blank. Okay. Now the question comes over there. As and when caveator anticipates some legal proceeding is to be filed against him in the near future, he can file a petition for a caveat in any civil court of original jurisdiction. Appellate court, High Court, as well as the Supreme Court. Civil courts includes Court of Small Causes, tribunals, forums, and commissions. However, in Deepak Khosla versus Union of India and others, the court held that Section 148 capital A of the Code applies to civil proceedings only, and caveat cannot be made against a petition made under the Criminal Procedure Code or petition made under the Article 226 of the Constitution of India. So it is clearly mentioned Civil Procedure Code where the caveat can be lodged. So as and when the caveator anticipate some legal proceeding to be filed against him, caveatee is the person who institutes the file, and the caveator is the person who is going to be indulged in that case law, against whom the case will be filed. The petition for a caveat in any civil court of original jurisdiction, Appellate Court, High Court, as well as the Supreme Court, but the civil courts include the Court of Small Causes Court, tribunals and forums and commissions. That is clearly mentioned in the Deepak Khosla versus Union of India. Section 148, capital A of the Code applies to civil proceedings, and a caveat cannot be made against the petition under the Criminal Procedure Code, or petition made under the Article 226 also cannot be made for the caveat. So that is very much clearly mentioned in that case law, Deepak Khosla versus Union of India. It is only the Civil Procedure Code, but not the Criminal Procedure Code and Article 226 of the Constitution of India. Who filed a caveat is the point. Just before we read it. A caveat under Section 148 capital A shall be signed by the caveator or his advocate. Where the caveator is represented by an advocate, it should be accompanied by his wakalatnama. A wakalatnama should be there that he is giving
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मागे। गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
We live in a world full